Good afternoon. Thank you all for joining today's webinar. Looking at my screen, I can see there's around 165 people participating. Now, crypto assets, and in particular cryptocurrencies, are rather controversial. They are a relatively new asset. In many cases, they exist only in virtual form, as an entry recorded on digital ledgers. They have an economic value, but they're not tangible. On the one hand, the perceived benefits of such assets include independence from government-related entities, the ease with which they can be transferred internationally, and the anonymity of market participants. On the other hand, they are associated risks of fraud, theft, and money laundering. Today's presentations focus on the nature of these types of assets as a matter of English law, whether they can be owned and whether ownership can be transferred. What remedies might be available to persons seeking to demonstrate ownership of crypto assets, to recover them from third parties, or to prevent their transfer? You'll be hearing from two junior barristers who have been involved in some of the few cases involving cryptocurrency claims that have been before the English courts. Sarah Bousfield was called in 2013, and based on a hugely impressive first few years at the bar, she was recruited to Brick Court Chambers in February this year. Her broad practice includes all aspects of commercial dispute resolution and public law. Sarah has particular expertise in civil fraud claims and obtaining preemptive remedies, including in the context of cases involving cryptocurrencies. David Heaton practiced as a solicitor in Australia before joining Brick Court in 2016. He also practices principally in commercial and public law disputes. David's been involved in litigation involving banks, financial institutions, and sanctions. He appeared unled in Robertson versus Persons Unknown, one of the first cases in which an asset preservation order was granted over Bitcoin in the commercial court. The session will be divided into three parts. First, you will hear from Sarah with an introduction of the key concepts characterizing cryptocurrencies and the blockchain. Then David will outline the legal issues concerning the nature of cryptocurrency, whether it is property, what type of property it might be, and as a result, what claims might be made by persons asserting ownership and what defenses to such claims there might be. The session will end with Sarah giving an overview of the interim remedies that can be applied for and providing some practical tips based on her own experience. After each of these three sessions, there will be time for one or two questions. So if a question occurs to you while you're listening, do please email it to me, alec.haydon@brickcourt.co.uk. Any question I use will not identify the party asking it, so please fire away while you're listening. I'll now hand over to Sarah for the first part of the session.
Thanks, Alec. So we're just going to pull up the slide to commence the explanations of key concepts. So if we go to the next slide. So what are crypto assets? They are tradable digital assets recorded on a distributed ledger. That ledger must use cryptography to verify and secure transactions. What is fundamental to all crypto assets is that they're built on blockchain technology. There are different types of crypto assets, including cryptocurrencies, which many of you will have heard of, but also tokens and crypto securities, which many of you may not have heard of. The term cryptocurrency is often used erroneously in a very broad sense, when in fact it should be distinguished from both tokens and crypto securities. Tokens are issued within a framework of what's known as an ITO, an initial token offering. They're used to raise funds typically for a project or enterprise, and they effectively embody a claim against an entity or its cash flows, assets, residual value, future goods, etc. Some resemble traditional instruments like shares or bonds, and some grant their holders access to specific products or services, which are commonly known as utility tokens. The term crypto securities refers to where the blockchain technology is used to register, issue and transfer shares and other corporate securities so that the capitalization table of a company is always accurate and up to date. So cryptocurrency, what I've included on this slide an excellent, if we go back to the previous slide, I've included on this an excellent summary of what a cryptocurrency is. I've pulled this from a paper which was commissioned by the European Parliament in July 2018. They were actually looking at investigating the implications of cryptocurrencies for financial fraud, financial crime, money laundering and tax evasion in particular. But nonetheless, there's some really interesting and helpful information there on some of the key concepts which we have to get our heads around in order to be able to understand crypto assets and the law. So cryptocurrencies are a digital representation of value. They are intended to constitute a peer-to-peer alternative to government-issued legal tender. That is also known as fiat tender. It's secondly to be used as a general purpose medium of exchange, again, independent from any central bank. Thirdly, it's secured by the mechanism known as cryptography, as already mentioned. And finally, it's capable of being converted into a conventional fiat tender and vice versa. There are currently over 1,000 different cryptocurrencies in the world. 2 of them are in general use, which most of you will have heard of. Bitcoin, which was developed in 2008, that's the symbol on the right-hand side of this slide, and Ether, which is the unit of currency on the Ethereum network, and that was introduced in 2013. Sometimes Ether it's misdescribed, sometimes including in some of the cases, as Ethereum being the term to denote the currency, when in fact it is Ether that's the currency and Ethereum that's the network. So moving on to the next sort of 3 slides, we've got 3 key concepts. The first of which is blockchain. So as I say, this is fundamental to all crypto assets. It's the record-keeping technology. So it's essentially a digital, decentralized ledger. It keeps a record of all transactions that take place across this peer-to-peer network. A couple of things that are most important for our purposes. 1, it's unchangeable. And 2, the vast majority of cryptocurrencies currently in circulation, so including Ether and Bitcoin, they are based on publicly accessible and permissionless blockchain technology. So when I say it's unchangeable, each transaction is time-stamped and linked to the previous one. So every time you have a new transaction, it becomes a new data set, also known as a block in the blockchain. The blockchain can only be updated by consensus between participants in the system. And each time a transaction is recorded, a time and date stamp is recorded and it can't be erased. So moving on, the next key concept is that of a wallet. As I say on this slide, it's comparable to a bank account. It's a device, program or service which stores a pair of public and private cryptographic keys. I've also heard it analogized to a keyring. The public key allows other wallets to make payments to that wallet's address. The private key enables the spending of cryptocurrency. A wallet which is stored or saved online is known as a hot wallet or hot storage. And an offline wallet is commonly referred to as a cold wallet or cold storage. And the images there in the middle and on the right-hand side of that slide are examples of what cold wallets can look like. A wallet comes with an address by default, but it's important to remember that addresses and wallets are not the same thing, which brings us neatly onto what an address is. So an address is an identifier of between 26 and 35 alphanumeric characters. And an address represents a possible destination for a cryptocurrency payment. Addresses are not intended to be used more than once. If you have a good wallet, it will automatically generate a fresh address with every transaction. But for our purposes as lawyers, it's therefore important to remember that addresses are not wallets, they're not accounts, they don't carry balances. They only receive funds and you don't send from an address at any time. So putting all this together, if we go on to the next slide, how does cryptocurrency work? At its simplest, cryptocurrency works by logging transactions into a database to figure out how much of a currency an individual or an address is holding. Put differently, one Bitcoin is a string of information recorded in the blockchain or ledger. In fact, when you think about this in a somewhat simplistic explanation, the way cryptocurrency work is not so different to how money in conventional bank accounts is spent or transferred. You think about it in those terms, you send money from your bank account to another account, and you do so by deducting from a digital figure that you have associated with your account, that being your balance. And then the digital figure associated with the other party's account is increased. There's nothing more than information being logged on a database here. There is no physical exchange. And cryptocurrency works on the same basis. There's a large log of information, namely transactions, that are used to determine how much of a cryptocurrency each address has. What is important to remember, however, is that there are two key differences between conventional banking and cryptocurrency. First, cryptocurrencies are purely digital. You can't take out a cryptocurrency in paper or coin form. The asset is therefore necessarily intangible. Secondly, cryptocurrencies are a decentralized form of currency. This means that when you spend a cryptocurrency, the approval of the transaction doesn't come from a central authority. So that's unlike a system like a bank or like something like PayPal. Rather, what happens is a peer-to-peer network of computers come together to form a consensus that your transaction is legitimate. Okay, so I think that's a whistle-stop tour of all of the key concepts that we have to bear in mind in order to understand crypto assets and the law.
Thanks very much, Sarah. That's a very concise and accessible explanation of what is obviously a complicated technical subject. We've had a request for some kind of detailed explanation as to what exactly happens when a Bitcoin is transferred from one person to another. Can you shed some more light on that?
Yeah, thanks, Alec. So I think in order to answer that question, it's important to remember that the digits at the end of the string of information that makes up an address, that is the public key, and that indicates the location of any Bitcoin or part of a Bitcoin at any time. And then the person with that public key is the person that owns that Bitcoin. When Bitcoin is transferred, what that means is that its location is changed by inserting a new key at the end of that string. That's only can be done when you link it with a corresponding private key, and that's entered into the software that's used to hold the Bitcoin.
Thanks very much. I think that means we're moving on to David's explanation of the nature of crypto assets.
Thanks very much, Alec. So building on Sarah's explanation of what crypto assets are and how they work, I'll now address three things. The first is whether crypto assets, and in particular cryptocurrencies, are property under English law. The second is how they are classified as property, and in particular, whether they need to fit within traditional classifications and why this matters. And the third is how, in the Robertson and persons unknown case, we framed claims against persons unknown to recover Bitcoin whose transfer was induced by fraud. I'll address the first two of these topics together because they're closely linked, then take any questions and then deal with the third. The first question, as I said, is whether Bitcoin and other cryptocurrencies are going to be recognized or are recognized as property under English law. Whether they are property matters for a number of reasons. Its main relevance for present purposes is that if not, you won't be able to make a proprietary claim to Bitcoin. But status as property also affects matters such as whether it can be devised, consequences on insolvency, and whether or not it might fall to be regulated under various regulatory regimes. The answer to that question, whether Bitcoin is property, appears to be a cautious yes. And I'll now explain the reasons for that. Prior to the Robertson case, as far as we could see, there was one case in the common law world that had been published that had considered whether Bitcoin was indeed property. And that was the decision of International Judge Simon Thorley in the Singapore International Commercial Court in the B2C2 case, from which you have a quote on the slide. In that case, Judge Thorley held that Bitcoin and Ether were indeed property that could be the subject of a trust. The specific facts of that case aren't relevant for present purposes. The key point is, of course, the quote on the slide, which held that the traditional requirements for the recognition of property in Ainsworth were made out in relation to Bitcoin and Ether. And the key requirements are that the property is definable, is identifiable by third parties, is capable of assumption by third parties, and has a degree of permanence or stability. It's noteworthy too that International Judge Thorley went on to hold that there had been a breach of the trust over the Bitcoin and Ether. So he applied that finding as part of the ratio of his judgment. And as far as I'm aware, that is the only final judgment in the common law world that deals with this question. As you can see, though, from the end of the quote, the contrary was not in fact argued before Judge Thorley. It seemed to us, though, in approaching the Robertson case, that there was, in addition to international precedents, an analogy that can be drawn between the decision of Mr. Stephen Morris QC, as he then was, in the Armstrong and Winnington case, and Cryptoassets. The Armstrong case considered whether EU emissions allowances, or EUAs, were personal property that could give rise to a proprietary claim in circumstances where a computer had been apparently hacked and EUAs transferred away according to their register. And it was held there that they were indeed personal property, and that in principle a proprietary claim lay to recover them. That was because EUAs were rights conferred by a statutory framework, they were expressly transferable by virtue of that framework, and they had value. Interestingly too, the court held that EUAs are not choses in possession, they're not physical or tangible property, but they're also not choses in action, they don't carry a right to sue someone, but they were nonetheless a form of intangible personal property, giving rise to a proprietary claim. And I'll come back to that when I address the second question. No doubt the analogy to Bitcoin is not perfect, but as I say, that was the argument that we advanced in Robertson, in particular by reference to the absence of any need for classification as a chosen possession or a chosen action. It seems to me that the best counter-argument to the view that Bitcoin is property is the argument that it is mere information and nothing more. If that view were correct, then the reasoning in cases such as that cited on the slide, the Your Response case, might apply. In that case, Lord Justice Morbick reaffirmed in fairly trenchant terms the view that in English law, mere information cannot be property. That was a case in which a defendant tried to assert a common law possessory lien over a database. So you might think it's perhaps not the most promising argument. It's fairly clear that whatever else the information is, it's not something that you can possess. And the Court of Appeal rejected the argument that a lien existed. What then is the principal difference to Bitcoin and other crypto assets, in particular cryptocurrencies? The key distinction seems to me to be between something that can be readily traded and is treated as functionally equivalent to money, so Bitcoin or cryptocurrencies, and certainly EUAs, albeit not functionally equivalent to money in the Armstrong case. And then something that cannot be traded or treated as equivalent to money, such as a database considered in Your Response. So in effect, it seems that the difference is as to the second and third of the Ainsworth criteria, that is, property being identifiable by third parties and capable in nature of assumption by third parties. But as ever, when one asks whether something is property and tries to apply that test, there is a degree of circularity involved. One ends up concluding that something is property more or less because people treat it as property. That is, of course, a very interesting theoretical debate, but the view that Bitcoin is property that grounds proprietary claim seems to be becoming well established by authority, such that it is a debate that one may no longer need to have in bringing such a claim. First of all, there's the decision in the Robertson case in 2018. That decision was not, in fact, published at the time of the Robertson hearing, but it seems to be the first, it has since been published, and seems to be the first decision in which an APO was granted in relation to crypto assets, their Bitcoin and Ether, by the English courts. In that case, though, again, as Mr. Justice Burst noted, neither party contended that cryptocurrency was not property and could not be the subject of an APO. Secondly, there is now the quite fully reasoned decision on this point in AA and Persons Unknown, and you have a longer quote from that case on the slide. Mr. Justice Bryan has there given fairly full reasons for his view that Bitcoin is indeed property that can be the subject of a proprietary claim. This is again a claim at the interlocutory stage and one made ex parte. It's worth noting too that Mr. Justice Bryan adopted the reasoning in the legal statement by the Law Tech Delivery Panel to the effect that English authority does not preclude a decision that there can be personal property which is not a chosen action or a chosen possession, albeit that was decided in the Armstrong case. So to sum up on this first point, whether Bitcoin is property, the trend of authority seems to be that it is indeed to be recognised as personal property. The two caveats are that the English decisions to this point are all interlocutory, so to the good arguable case standard only, and secondly, to be a case contrary position has been argued. The second question is its nature. And the nature of that property is important because it affects both how you can deal with that property, though to some extent that's a question of nomenclature and formalities. And then secondly, perhaps more importantly, which defences might be available to a proprietary claim. In general, and this is fairly trite, English law divides personal property into choses in possession, tangible thing you can own, and choses in action, a right to sue somebody for something. It's an obvious point, but you have different kinds of dealings with those kinds of property. For example, you can have a possessory right over a chosen possession, but that's not possible for a chosen action. And similarly, you can't assign a chosen possession. You need a different form of disposition to deal. Perhaps more significantly, it's not possible to have an action. So the cause of action, your cause of action will vary depending on this classification, where Bitcoin is misappropriated. There's also an important division between cash, banknotes and coins, and other tangible and intangible personal property for the purposes of defences to a proprietary claim. Just bring up. So for tangible and intangible property, the basic rule is that if you don't have title, you can't pass title to anyone, even a good faith purchaser for value. That is the Nemo-DAT rule. And there are, of course, exceptions to this, in particular in the context of sale of goods under the Sale of Goods Act, the good of a seller by their purchaser, and also many old common law exceptions in relation to goods. Certainly the starting point is Nemo-DAT. By contrast, it's well established that for money, that is cash, there is always a defence of good faith purchase for value, where money is passed on, misappropriated money is passed on to a third party. In effect, whenever money is used to buy something, the person receiving the money, if they do so in good faith and they are giving value, gets good title. And that's reflected, for example, in the rule that cash cannot be converted, that is subject to a claim in conversion. The question then is how Bitcoin is to be classified and with what consequences for defences to a proprietary claim. That is again a question that has not been fully worked through in the authorities. In a 2016 paper, the FMLC has suggested that Bitcoin should be treated like cash because it was said that its use was functionally equivalent to cash. And in addition, the FMLC seemed quite concerned to ensure that there was always a good faith purchase for value defense in relation to dealings with crypto assets. That is an interesting suggestion, and one can see some analogy to deposits with banks. Now, if it's right to suggest, as the FMLC does, but by reference to academic literature, that those, that is to say, money on deposit with a bank, is to be treated in the same way as money for legal purposes, that analogy might be considered quite attractive. The difficulty, in my view, is that it involves treating Bitcoin as tangible property, that is, a chosen possession. And so, in fact, the analogy seems to break down quite quickly. There's no equivalent for Bitcoin to cash. That is, you can't turn it into banknotes and coins, as Sarah has explained, other than, of course, by trading it. And that seems to be a meaningful distinction, both from cash and banknotes, physical money, and from deposits in a bank. It's also not entirely clear that the rule of good faith purchase for value does apply to funds held in a bank, as opposed to physical manifestations of money. If the FMLC's view is correct, there would always be a defense of good faith purchase for value to a proprietary claim against Bitcoin, even if a transfer was not authorized or is otherwise void, because it's to be treated in law in the same way as money. The other view is that it's a form of intangible personal property, but not a chosen action. I mentioned before that Armstrong had expressly recognized that it's possible for such property to exist and so held in the context of EU allowances. AA is also fairly clear in reliance on the Law Tech delivery paper that Bitcoin may be a form of intangible personal property other than a chosen action, albeit in AA, nothing was suggested to turn on this, and there was no suggestion made that Bitcoin should instead be treated as analogous to money. If it's right to treat Bitcoin as intangible personal property, then it seems to me that in principle, the Nemo-DAP rule ought to apply. So where there is no transfer of title to the Bitcoin to a person who misappropriates it, so where, for example, it's stolen or a purported transfer is not authorized and therefore void, a subsequent recipient of that Bitcoin would in principle not have a defense of good faith purchase for value. The true owner's title would prevail. However, the contrary view appears to have been taken by Mr. Stephen Morris QC, as he then was, in Armstrong. So there he held that where an EUA was taken without any express transfer of title, the computer was hacked and the EUA was transferred away from its owner and was then on-sold, the recipient did indeed have a defense of good faith purchase for value to a proprietary claim in principle. His Lordship, as he now has considered that to follow from the decision of the House of Lords in Lipkin-Gorman. But it might be said that that reasoning has some difficulty because Lipkin-Gorman was ultimately a case considering money, where the defense of good faith purchase for value is well established. And I would say with respect that there's not really any attempt in the judgment, and it might well reflect the submissions made, to grapple with the Nemo-DAP principle, or to explain how somebody who takes the property is able to give better title than they have. On the facts, it was ultimately held that the purchaser had notice of misappropriation, and so the defense failed. It seems to me, for what it's worth, that it's arguable that Armstrong was incorrect in this regard, albeit didn't actually matter on the facts. If Armstrong reflects the law, however, then the classification of Bitcoin matters less, because there would always be a defense of good faith purchase for value, whether Bitcoin is on-sold or passed on to another party. It's worth mentioning the possibility of a change of position defense briefly. Notwithstanding the parties' agreement in Armstrong that such a defense would be available, it was rejected in Armstrong. Mr. Justice Stephen Morris, as he now is, considered that this was a defense to a restitutionary claim for unjust enrichment, so a claim for the value of the Bitcoin, but would not affect the ability of someone to assert their title to an asset. That appears to me to be correct in principle and to follow from the decision in Foskett and McCown, which is cited. So it seems unlikely that one could have a change of position defense to meet a proprietary claim. That then deals with those first two questions, whether Bitcoin is money and how it's to be classified, with what consequences in particular for defenses to proprietary claims.
Hi, David. Thank you again for that explanation, which, if I may say so, was also extremely clear and very helpful. It's a particularly interesting point, the last one you've been discussing. A question's come in for you, and I'm afraid I'm not sufficiently familiar with all this terminology, but I think Sarah explained that there's something called a cold wallet, which is a physical device, such as a USB key, which is used to store the private key for a Bitcoin. Now, obviously, that can be possessed. If someone takes the cold wallet containing the private key for Bitcoin, the Bitcoin may still be there, but the owner will not be able to use it. How would he seek compensation for that kind of loss?
That's a really interesting question, Alec. And as far as I'm aware, nothing in terms of decided cases has addressed that. There's probably two claims. So assuming that you have a proprietary claim of some kind to the Bitcoin, the kind of claim we've just been discussing, the owner would be able to make that. But in addition, what you might be able to say for that kind of situation is that there's also a claim in conversion in respect of the actual cold wallet, the device that contains the private key that's being taken. And you may be able to draw an analogy to older cases which say that where a physical manifestation of a chosen action, so a negotiable instrument, is converted, the loss caused by that conversion is the value of the instrument itself. If that were the case, what you might be able to say against the person who takes your private key is, because you've effectively deprived the owner of the ability to deal with that Bitcoin, their loss from conversion is not just the value of the USB key, which is going to be fairly small, but the value of the Bitcoin that can no longer be used, but still to be worked out.
Thanks very much, David. You're going to continue now, I think.
That's right. So I'll now turn to explain briefly the facts in Robertson and the manner in which we identified the defendants and ultimately framed claims for the recovery of Bitcoin in that case. And then I'll hand back to Sarah to discuss interim remedies. You have on the next slide here a summary of the facts in the Robertson case. The key points, as you can see there, were that Mr. Robertson had 100 Bitcoin worth about 1.2 million US. Some reports of the case put the value of the Bitcoin at 1.2 billion. It would have been excellent to be doing a case seeking to recover 1.2 billion on my own, but that was not, in fact, the position. Mr. Robertson intended to invest the Bitcoin with an investment firm, and in fact intended to receive for it shares denominated in Bitcoin. He was the victim of a spear phishing attack. So the fraudster, the first defendant ultimately in our claim, impersonated the people at the investment firm by hacking one of their email addresses. And in consequence, he was able to communicate with Mr. Robertson and procure him to transfer his Bitcoin not to the investment firm, but instead to an address supplied by the fraudster. It was quite an elaborate and effective fraud. He did quite a good job of impersonating the investment firm. That came to light when the person at the investment firm who had been corresponding with Mr. Robertson saw in his outbox various emails that he realized very promptly he had not in fact said, and saw that a transfer had most likely been effected to the incorrect address. Chainalysis, a blockchain investigation firm, was able to establish that 80 of the Bitcoin had been transferred to a wallet of Coinbase UK Limited and an associated entity. And if I just show you on the next slide, you can see how those transactions work. So the initial transfer of 100 Bitcoin was to an address controlled by the fraudster. And then there was an onwards transfer of 80 Bitcoin to the second defendant. That was a person who held, if you like, an account with Coinbase, a transfer to Coinbase's public key. And Coinbase, you can see on that slide, is defendants 3 and defendants 4. And then the other 20 Bitcoin, worth about $200,000 were effectively dissipated. And you see that by the chain of transactions running along the bottom and up the right side and top of the slide. So each of those transactions, a little bit was siphoned off, most likely converted into fiat currency or another form of cryptocurrency. Mr. Robertson and his solicitors approached Coinbase, told them that this had occurred, and asked them if they would freeze the Bitcoin that had been misdirected. Coinbase, interestingly, agreed to do that for a few days, but would not do so for any length of time without a court order. They actually had the ability under their terms and conditions, as do most financial institutions, to freeze money in their clients' accounts. In addition, Coinbase, of course, as you would expect, refused to disclose any of the details of the account holder of D2 without a court order requiring that. So it was therefore necessary to approach the court both for bankers' trust orders and for an asset preservation order in relation to Bitcoin. That is to say, the 80 Bitcoin still with Coinbase. The first difficulty we faced in doing that was identifying the defendants, because initially we didn't know anything more than the blockchain addresses and the transfer ID, which Chainalysis was able to identify. The claim was therefore one that had to be brought against persons unknown, and what is then required is sufficiently to identify the defendant by reference to what information one has. What we did in this case was to identify the defendant by reference to having procured the transfer and by reference to the specific transaction ID of that transfer from the source wallet to the destination wallet, and of course in the amount of the Bitcoin. That is a unique transaction reflected in the blockchain, as Sarah has explained. And so neither of the judges before whom we appeared, Mrs. Justice Mulder or on the return Mr. Justice Jacobs, had any concerns about the first defendant being sufficiently identified. The second defendant was identified in a similar way at the initial hearing, and then by the time of the return, we had received bankers' trust disclosure and therefore had further information. How then did we actually frame the claims in Robertson on those facts? The nature of the claim that one brings obviously depends on the particular facts in question. And the key object in framing a claim to recover property is always to get to a proprietary claim if one can. So that the claimant is able to say against whomever now has the asset that the claimant has better title, or it would be unconscionable for the defendant or recipient to retain it, and so it should be restored. Bitcoin, on the one hand, presents quite unique opportunities to do this, because it will be apparent from the blockchain to some extent where the Bitcoin is, so at what public key, as was the case in Robertson. But as is also the case in Robertson, the entirety of the transactions between the various public keys and addresses to which Bitcoin is sent will not necessarily be apparent. In particular, the parties to those transactions won't necessarily be apparent. And in addition, whether there has been some kind of payment in either a crypto asset, a fiat currency, or some other valuable exchange won't be apparent.
Must be holding up.
On the other hand, too, the blockchain may make it difficult in practice to get an effective remedy. If you take the facts of Robertson and assume that it was money that had instead been transferred to Bank 1 and then Bank 2, and for example, the second defendant, as was the case, never formally responded, didn't bother to defend the claim, one could obtain default judgment or summary judgment and obtain repayment from the bank with the asset fairly readily. But with crypto assets, at least cryptocurrencies such as Bitcoin and Ether, you can't actually compel a correction to the blockchain unless the person who has access to it is willing to insert their private key. So you may not be able ultimately, even if you have a judgment in your favor, to regain those crypto assets in a way that will be recognized by the world at large at the end of the day. In framing these claims, there's also the further complication of what is the proper law applicable to transfers down a chain, as was the case here, for example, with those 20 Bitcoin, and indeed with the 80. There is a possibility that a foreign law might treat a transaction as conferring good title to property, where English law would not. And in general, you would expect under English choice of law rules, or at least there is a possibility that that foreign law may apply. Robertson was a relatively simple case. There's only one step from the first defendant to the second defendant who had the 80 Bitcoin, so not too many opportunities for good faith purchase of value, though this concerned Mrs. Justice Mulder, that possibility. And the second defendant, as I mentioned, didn't formally respond to the claim and make any arguments, for example, that under Nigerian law, good title had passed to him. And indeed, after we got initial orders for an APO and the Bankers Trust disclosure, when we contacted the second defendant, he said that he was in Nigeria and the KYC, or what appeared to be KYC information we got by way of disclosure, suggested that was the case. He said that he was a cryptocurrency trader who had been sent 80 Bitcoin by Mr. Dave, the first defendant, to convert into Litecoin. Mr. Dave had asked the second defendant to pay a deposit while he held and converted that Bitcoin, but the deposit transfer transaction had been rejected. So the net effect was that D2 had not paid consideration, not given anything for the Bitcoin. And the second defendant indeed agreed to accept service by email. So he had, it has to be said, an unusually cooperative defendant. By the time we came to seek permission to serve out, we prepared particulars of claim that put the proprietary claim against D2 in three ways. First, we said that the initial transfer of Bitcoin by Mr. Robertson to D1 was void and of no effect, on the basis that Mr. Robertson had made a mistake about D1's entity. The effect of that was that he retained title to 100 Bitcoin as against D1 and as against D2 to the 80 Bitcoin. That is to say, in law, there was no effective transfer. And we sought to draw an analogy there to the case of Shogun Finance and Hudson. That case held that, in effect, where a contract wasn't made face-to-face and the counterparty is of importance, where a person purportedly contracts with B, but in fact a rogue pretends to be B, the contract is void, or more accurately, the offer by A to contract with B is not capable of acceptance by the rogue, and so no contract comes into existence. In consequence, there's nothing to transfer any title to the rogue, and the rogue can't give good title to other people in relation to any particular property, subject to the various statutory and other exceptions I mentioned earlier. Here we said that while there was no contract between Mr. Robertson and the rogue, to be effective as a transfer, Mr. Robertson would have had to either assign or make a gift of the Bitcoin to the fraudster, the rogue, and for that purpose he would have had to have an intention to dispose of the property. So the argument was, by analogy to Shogun, there was, in law at least, no such intention. And on that basis, Mr. Robertson retained title to the Bitcoin as against D1 and against D2. The argument there would be, in principle, there's no defense of good faith purchase for value for the reasons I explained earlier, but Armstrong is contrary authority to that point of view. That issue was avoided in Robertson because by the time of return, we knew that D2 had not given any consideration for Bitcoin. The second way in which we put the claim was to say that the initial transfer was voidable and was rescinded by the bringing of the claim for, in consequence of D1's fraudulent misrepresentations as to his or her identity. That's a fairly standard rescission for fraud kind of claim. And the argument was again that D1 was not able to pass any better title to D2, that is to say, title free of Mr. Robertson's right to rescind, than D1 himself had, again, you would come up against the same issue as of good faith purchase for value had that been live on the facts. The third way in which we put the trust, which would put the claim rather, which was particular to the facts of Robertson, was by way of quis close trust. That was because it would have been apparent to D1 that the purpose of this transfer was quite specific. It was to be invested in a firm in exchange for Bitcoin denominated shares. The first defendant must have known that, we said, when he procured the transfer, and Mr. Robertson only intended to transfer the Bitcoin for that purpose. Accordingly, when they weren't used for that purpose, they were effectively held on a quis close trust, which the fraudster breached by misappropriating Bitcoin. It was necessary then, as against D2, to allege that in the circumstances he was tainted with knowledge so that he would be not liable as a knowing or unconscionable recipient of the Bitcoin. And we felt in the circumstances able to allege that on the basis of what he had said to us about the circumstances in which he came to receive the asset. And further, by the time we came out to plead out the case, by virtue of the proceedings and our communications with him, it was plain that D2 would have been aware that the Bitcoin were not, or at least we said, the Bitcoin were provided to him by way of breach of trust. So those were the ways in which we framed the claim to recover the Bitcoin in Robertson. But as I said at the beginning, any framing of the claim would necessarily be very fact specific. And in particular, in situations where there is a contract, it would probably be necessary to attack that contract itself. Conversely, where somebody accesses a system and effectively steals Bitcoin, the simplest and easiest claim might simply be to say that the initial transfer was not authorized, and so there is no viable transfer of title.
Thanks very much, David. You commented during that part of your presentation on the possibility that different countries would take different views of transactions. That's aroused some interest in one of the participants on this webinar, who notes that crypto assets, being a new class of asset, not previously envisaged by the law, really calls out for some kind of international agreement on how to deal with transactions. And it's been pointed out that other countries, such as Japan and Spain, have actually decided that crypto assets are not property. So far as English law is concerned, which is of course what you're addressing, so many of these cases have been ex parte, so or without anyone being represented.
Yes.
Are you aware of any case where it's actually been argued that a crypto asset is not property under English law?
Alec, no. As I said in the first part of the presentation, I'm not aware of any such case. I think the best authority that we can rely on for the moment in that regard is the Singapore decision, where you at least have a final judgment that holds that cryptocurrency can be the subject of a trust and was indeed the subject of a breach of trust. But as you rightly say, the contrary position was not taken. So we're yet to have a fully argued decision, as far as I'm aware, anywhere in the common law world, as to the status of Bitcoin as property and the nature of claims that may be capable of being made in relation to it.
Thanks very much, David. I think we're now passing on to the final part of the session. Sarah's going to address interim remedies.
Thanks, Alec. Yes, so we've heard a little bit about what kinds of interim relief can be used in respect of crypto assets from David's explanation of some of the key cases. So starting off, freezing orders. We have seen a freezing order of cryptocurrency here in the UK in the case of Robertson. In that case, the applicant transferred funds to Nebius, which was a trading platform which essentially acted like a bank for the applicant. After transferring the funds to Nebius, the applicant became concerned that the money had been dissipated. An application for a proprietary injunction and a freezing order was therefore brought. And at the hearing, counsel for Nebius tried to argue that the monies were still in the possession or control of Nebius. But one of the documents that was produced by them appeared on close inspection to have been doctored. Effectively, the claimant's name and the date looked as though it had been compiled with a composite document. There'd been something overlaid over it. So in that circumstance, the applicant averred that, in fact, that evidence was evidence of there being either a real risk of dissipation or, in fact, that the funds had already been dissipated. The court agreed and made the freezing order against Nebius and two of its directors up to the sterling value of approximately 1.6 million. So that's a good decision for showing that freezing orders are possible in respect of crypto assets and also a proprietary injunction. It's worth just pausing there for a second and reminding ourselves that proprietary injunctions are slightly different from freezing orders. Sometimes they can be misdescribed as freezing orders. In fact, they're different, and the court's jurisdiction and therefore the applicable test when deciding whether to grant one are different. What's key is that you don't have to show the risk of dissipation for a proprietary injunction. It's worth also mentioning that when doing this in respect of cryptocurrency, we might feel a bit uncomfortable about how we actually do that in practice, how we make a proprietary injunction attached to the specific Bitcoin or Ether that we have in mind. It's actually, in fact, relatively easy to achieve this. The order must simply specify the address and transaction ID of the user who made the transfer in order to ensure that the proper Bitcoin or Ether, which was misappropriated, is effectively captured. We've also heard about the APO which David obtained in the Robertson case. Clearly, as that case demonstrates, that's an option. That is a very useful tool, again, because we don't have to show a risk of dissipation of assets. What's key is effectively there's a dispute to the parties' entitlements to a particular property, and this order ensures that the named assets are held in the status quo pending a determination about who is entitled to the property. Again, you can ensure that you capture the precise asset that you are targeting by specifying the address and transaction ID, which I understand from David is what he did in the Robertson case. Now, the rest of the talk I'm going to look at the latter 2 points on this slide, namely disclosure orders in relation to claims for cryptocurrency. So they take two forms: bankers' trust orders, as was made in the case of Robertson against Coinbase in the UK, and then the Norwich Pharmacal order, of which I know there has been at least one made against a different exchange in the UK known as Bitstamp. However, that was heard in private, so we don't unfortunately have the benefit of a public judgment. In both cases, what then happened was the respondents in practice complied and disclosed details about the e-wallets under their control. So just briefly, bankers' trust orders, these are typically used in respect of banks, but they can also be used in respect of crypto assets where you can find an appropriate entity like an exchange, as was the case in Robertson Coinbase. And the principle is that where there's strong evidence that the claimant's property has been misappropriated, the court will not hesitate to make strong orders to ascertain the whereabouts of that property. Norwich Pharmacal orders have a similar effect. They require the respondents to disclose certain documents or information as named within them. And what you have to show is that there's been wrongdoing. There's a real prospect that the respondent is somehow mixed up with, facilitated, or involved in that wrongdoing, that they have the relevant information, and that the order is necessary and proportionate. So one thing that it is worth mentioning is that doubt was cast in the decision of AA and persons unknown, as referred to already by David, as to the availability of relief pursuant to an NPO, a Norwich Pharmacal order, or indeed a banker's trust order, where respondents are out of the jurisdiction. However, as I say, we have had examples of successful orders within the jurisdiction, And I think it's helpful to now give an illustration of how cryptocurrency can be traced in practice by reference to one of those examples that I've mentioned that I know about was given in private. Somebody has actually fortuitously asked a question about how you, in practice, can trace assets where you've got notwithstanding the decentralized nature of cryptocurrency, as I explained at the beginning of this session. So the challenge is that, unlike where you're dealing with a conventional currency and conventional transactions, which will involve a centralized authority like a bank or PayPal, it's obvious that you can go directly to that entity and target them using your banker's trust order or your Norwich Pharmacal order. And the challenge then is, well, when you don't have that centralized authority, who can you go to? Who can be the subject of these disclosure orders? So if we can move on to the next slide, I think that what this is linked to, this problem, is the problem of anonymity. The prospect of linking an address within a UBO can seem totally daunting in light of the particular facets of cryptocurrency. However, it's not as difficult as it may first seem. And that's essentially because cryptocurrency users will typically convert to another asset quite quickly. And then what you're trying to do is trace them at the point that they do so. And it's increasingly common that that is actually possible in practice. So when people talk about the problem of anonymity, what I think it's important to remember is that cryptocurrencies do not give anonymity. I think the better way of thinking about this is, as Lord Hodge so aptly put it in his address in October 2018 to the East China University of Political Science, cryptocurrencies afford only pseudonymity. That's a state of disguised identity. So we have to just be a little bit patient. If there's been a misappropriation of assets, obviously it's important to move quickly. But then, having started down the train of the tracing exercise, sometimes we have to just wait a little while, a little bit of patience, in order to see when there'll be a rub with the real world. So when they will start, the fraudster will seek to move those assets from cryptocurrency into another conventional asset. And at that point, we can try and identify the individuals controlling the wallet. So if we go on to the next slide, this is also known as breaking cover or coming off grid. Blockchain requires, I think we're just waiting for the slide to come up. I'll carry on. I think there might be a problem with the slides. So this is the concept of breaking cover. Blockchain requires the UBO to be visible as a user. They have a user ID. So on the blockchain, we know who the user is. And we know, as explained before, that with most cryptocurrencies, every transaction will be publicly and indelibly recorded on a blockchain because that blockchain is made publicly accessible and is permissionless. So when a user breaks cover and comes off the blockchain grid, the nature of the blockchain then comes back to bite the fraudsters, as every single transaction which has been made up to that point of coming off grid is recorded, so we can retrospectively start looking back. For instance, when they convert cryptocurrency to acquire conventional currency, there'll be a coming off the grid or a breaking of cover. And in my experience, as I say, the tracing efforts so far have proved highly effective in respect of cryptocurrency because of the way that blockchain works. So moving on to the next slide, to give an example from a previous case, the client only knew the address where fraudulent funds had been sent. And a forensic analysis on this address was undertaken by Quintel Intelligence, who are a litigation support specialist with expertise in conducting these complex tracing exercises, including with the likes of cryptocurrency. There was a significant amount of work done on analysing data on the dark web, but what effectively then happened was the transaction, the address that had been used to effect the transaction was then linked to a number of wallets. We still didn't know the UBOs of those wallets, so it wasn't a situation as in AA and persons unknown, but what Quintel were able to do was to determine that the fraudster had used a brokerage at some point, and this is what this slide shows. So at the top of that pyramid, that was the 200 Bitcoin being misappropriated, and then all those lines that flow down from the top of the pyramid are each of those Bitcoin transactions. So it's the 200 Bitcoins being dispersed. And on the left-hand side, you'll see that there was a particular transaction focused upon. What happened was Quintel focused on a series of very small value transactions. And by cross-referencing that data with other metadata in relation to the address, they identified that a particular UK-based brokerage firm had been involved in that particular transaction that's highlighted in the square box on the left-hand side. And so we found then that Bitstamp, like Coinbase, had been involved and had charged a small brokerage fee. That then meant that they could be named as the respondent in the Norwich Pharmacal order without the judge being concerned about it being a fishing expedition. And in that instance, the brokerage firm complied extremely promptly with the NPO, provided a wealth of information such as all the electronic conversations with the UBO, IP addresses, etc., all of which in turn then allowed further work to be done to identify and locate the UBO. So then, finishing up, in terms of practical advice, I think what's really important as lawyers is that we do all that we can to explain the technology accurately and succinctly to the courts in order to ensure that the proper form of disclosure is framed within any order. There are a number of generic characteristics of cryptocurrencies, as I've summarised in this presentation. There are equally other characteristics, particularly in relation to the platform for storing and trading, which can differ quite widely. So we need to be quite precise in the way that we explain and give evidence about how certain cryptocurrency platforms actually work. And it's also important when looking at the interface between conventional platforms and with cryptocurrency, that we see how there's an accurate explanation of how that interface actually works. Otherwise, there's a real risk that our disclosure orders are misdirected and ineffective.
Thanks very much, Sarah. As might be anticipated, actually, it's the practical implications of all these legal principles and their application that is of most interest to people tuning into this webinar. And the provision of information by third parties is obviously of crucial importance to claimants wishing to pursue a substantive claim. You've mentioned the possibility of applying for an order requiring third parties mixed up in wrongdoing, but who are not themselves liable, to provide information to claimants. A question's been asked about the availability of that kind of relief against third parties who are outside the jurisdiction of the English court. In the most recent case of AA versus persons unknown, Mr. Justice Bryan indicated that his view might be that there was no jurisdictional gateway permitting service of a claim form seeking a Norwich Pharmacal or Bankers Trust order out of the jurisdiction. Is there any way you can see around the problems that have been identified to date?
Yes, I mean, in short, Alex, I can. And I think what's important to first be clear about is exactly what was said in AA and persons unknown. So Mr. Justice Bryan referred to two decisions in particular, and I'll give a summary of those. What he said was, in light of those decisions, he thought there were potential difficulties that could possibly arise in relation to the applicant's ability to satisfy a jurisdictional gateway through which the claim for the Norwich Pharmacal order relief could pass. And what happened in response is that the counsel for the applicant, partway through his application, invited the judge to adjourn both the Bankers Trust order application and the NPO application. So the matter wasn't actually determined. There's some, slightly negative commentary, but we haven't actually got a definitive decision by Mr. Justice Bryan. So I think it's therefore important to just explain exactly what was said in the cases that he referred to. The first of which is AB Bank, an Abu Dhabi commercial bank. And in that case, that was in 2016, that wasn't a cryptocurrency case. That was just an MPO made against a UAE bank, and the High Court set aside the MPO on the basis that it didn't have jurisdiction to permit service out of that application. And Mr. Justice Tier stated that the claim didn't come under any jurisdictional gateway, in his view, under Practice Direction 6B. He said, first, the relief wasn't an interim remedy. He said the MPO was in fact a final order, so you couldn't go through that gateway. He said that the act sought from the bank was a search in the UAE, and that the fact that the MPO stated that the information that was found pursuant to the search would simply be provided by witness statement or affidavit meant that at no point in that exercise was the court ordering an act within the English jurisdiction. So you couldn't go through that gateway. And then finally, the bank wasn't a necessary and proper party in his view. It's also worth noting that in that case, Mr. Justice Tier commented that he didn't think that even if there was a jurisdictional gateway, he wouldn't have ordered the MPO. He found that there was a way of seeking that information within the UAE via the central bank. And so he said, there was no exceptional circumstance or urgency that would require the court to avail of an MPO in any event. So then the other decision, which is more positive, is that of CMOC and persons unknown before Mr. Justice Waxman. That was a year later in 2017. And there the commercial court did just give a banker's trust type relief and found the respondent was a necessary and proper party, and so used that jurisdictional gateway. But the slight fly in the ointment is that it doesn't appear that Mr. Justice Waxman was referred to the decision of Mr. Justice Tier previously. So, and this is what was picked up in AA and persons unknown. Nevertheless, in another context, I've personally persuaded Chief Master Marsh in a hearing that was heard in private to make an MPO against a respondent in relation to a cyber squatting case in that instance by confining AB Bank on its facts to situations where the NPO doesn't specify where the information is to be provided. So what I did instead was I included in the MPO that once the search was undertaken, the information was to be delivered to a solicitor's address within England, within the contents of an affidavit. And so I said on that basis that the court would then be ordering an act within the jurisdiction, and therefore that gateway could be used. It worked in that instance, but plainly we are in need of a High Court decision clarifying this issue. It doesn't just affect the tracing of crypto assets, but plainly it's very important for them. If we don't get a decision that falls down and confines AB and Bank in the way that I suggest, then we are going to be stuck with NPOs and bankers' trust orders only in respect to respondents that are based in the jurisdiction or where they submit to our jurisdiction.
Which would obviously be quite limiting given the decentralized and widespread use of these assets. For what it's worth, your view about the potential gateway is shared by a very distinguished former Lord Justice who made that point from the floor at one of the Brick Court commercial seminars. So definitely something to be thinking about in the future if we're applying for that kind of relief. Right, now we've come to the end of our time. It remains for me to thank David and Sarah very much indeed for the time that they've spent putting together these talks. They are obviously hugely familiar with the issues that arise in this area, and they've explained it in an incredibly accessible and well thought out way. So thank you very much. Thank you to Paul Gray for organising this session and for Brick Court's IT department for setting up the webinar. Thank you to all of you for attending. I hope you found it as informative and helpful as I have. And thank you for submitting so many questions during the session. I'm sorry if I didn't get round to asking all of them, but time constraints apply. I have been asked about the availability of the slides, and the intention is to release them sometime next week. This session is also recorded, so you'll be able to look at it again should you wish to do so. Thanks very much, everyone. Goodbye.